Welcome to the Virtual Center for the Study of the Constitution and Civic Responsibility, an ongoing inquiry into American political origins and evolving institutions. The Virtual Center's Executive Director is Dr. Bill O'Brien. He's also your host for this ongoing conversation. Here he is now, Dr. Bill O'Brien.
Thank you, Bob Kincaid, and welcome to the Virtual Center for the Study of the U.S. Constitution and Civic Responsibility. It is a Tuesday. It is the 25th day of March, and it is snowing. And it's hard to believe. It just won't seem to quit, will it? It is a pleasure to be with you today. Could not do a program at the regular 4 to 6 p.m. Hour yesterday. Mainly because I was having new windows installed in the area that I broadcast from, and I had to shut down the computer and everything else while they took out the old windows and put in the new ones and caulked them and all of that, and they were here a good portion of the day, but I kind of knew that it would probably take a while, and indeed it did. It was not until after 5 p.m. that they finished up yesterday. So I thought it was better, and I had called Bob and told him that we better run a repeat program yesterday just to be sure and to be safe. And it turned out that indeed it was. I knew that if time started to get really close, it was going to be difficult and stressful. So it seemed better to just do a repeat program yesterday. But we're here live and kicking today, and it is a pleasure to be with you on this Tuesday. It is the 25th day of March, and we're getting some very, very positive indications of weather change over the next 4 or 5 days, which suggests that this might indeed be it. But it is extremely cold for this time of this late in March. And, everybody is kind of just shaking their head and say, oh, no, not again, not one more time or whatever. It is a pleasure to be with you. I understand that our phones are operative once again. And so I encourage you to make yourself heard and give us an opportunity to listen to your views and your ideas and suggestions and comments and your thoughts and reflections on issues that we've been dealing with or that we will continue to deal with in the future, or issues that you think we ought to be dealing with. Our phone number is area code 304-658-3333. That's 304-658-3333. My email address, waobrien906@gmail.com. That's waobrien, BRIEN 906@gmail.com. Let me begin. Before we get into anything today, let me alert you that tomorrow we're going to be beginning an hour early. In the East, we'll be running for our program from 3 to 5 in the afternoon. It'll be 1 hour earlier. I have a board meeting at 5:30 here in town, which I have to chair. And so I'll have to be, up and out of here a few minutes after 5 tomorrow evening in order to get there in time. So, tomorrow is our third day of the week. It'll be our final program of the week, and it will begin 1 hour earlier. So I just wanted I'll try to remember to announce that as we begin our second hour as well, because I know we'll have some people joining us for the second hour that may not be with us right now. Let me. There are so many issues. Let me, touch on a few things. Supreme Court today heard arguments in the Hobby Lobby case, which is getting an awful lot of attention nationally, and it's Sibelius versus Hobby Lobby stores, and it is being linked or combined with another case. Conestoga Cabinet Company, I believe it's called. It's a Mennonite company, and it has many of the same arguments, First Amendment arguments, against the contraceptive mandates within the Affordable Care Act that it has caused Hobby Lobby to raise this issue and bring it all the way to the Supreme Court. The point is that the court listened to arguments today, and I just read a report on the hearings that were held today. The court is expected to make a decision in June, late in June, on this particular case. It is extremely an extremely significant case for a number of reasons, and it's an issue that I really think, obviously, because it's a First Amendment issue, it obviously falls within the mission of our attention here at the Virtual Center. I think, but beyond that, I think this case has significant issues and implications for a lot of things, and one of them is an issue that we spend quite a bit of time on here at the Virtual Center, and it is the extent to which the Citizens United decision of 2010, which found that corporations as persons were entitled to First Amendment freedom of speech rights, specifically the right to contribute money to political campaigns as an expression of speech. And the idea that corporations come under the First Amendment when it comes to freedom of speech is, of course, a major argument of those arguing in support of Hobby Lobby in this case. Because the argument, and it seems to make perfect sense on the surface, if Hobby Lobby is entitled to First Amendment rights to free speech as a person under the First Amendment, why should it not also be entitled to First Amendment religious freedom rights under the First Amendment? And so on the surface, that seems to be a very, very powerful consideration. And there's absolutely no question that one of the issues that makes this case so significant for the future of the Constitution and interpretations of the Constitution was contained in the 2010 decision, Citizens United. Because by asserting that corporations were indeed persons under the First Amendment, the court, in effect, opened up the question as to whether the entire Bill of Rights, which is obviously available to protect the rights of persons, would also apply up and down the line to corporations. And now here's the first major case to test that implication, namely religious freedom under the First Amendment. So that particular case, it seems to me, is very significant. Over the weekend, I ran across a column. It just goes to show that you just never know where relevant information is going to surface. You know, here at the Virtual Center, for example, you know, I start to plow around looking at op-ed pieces and news around, you know, from various national journals and those kinds of things, and you just never know. And there was an article in the New York Times a few days ago by Linda Greenhouse, and Linda Greenhouse is the New York Times reporter who covers the Supreme Court. And she wrote this what I think is absolutely brilliant article about being blindsided, but in a positive way, by a Supreme Court decision that was rendered very recently. In fact, it was the most recent decision of the Roberts Court. The decision was 8-1, and the majority opinion was written by Chief Justice Roberts. And it's a property decision. It deals with the issue of private property. And Linda Greenhouse's whole point was that she kind of blundered into this decision. She didn't know anything about it, the circumstances of it, and when she read the majority opinion, it was 17 pages long, and she said to her it just didn't say anything relevant. It was full of property jargon, property rights jargon, and makes reference to the fact that Justice Breyer, in the course of hearing the case, Justice Breyer made mention to the fact that his ability to grasp the legalisms associated with this property case were being tested, and he recalled his days at Harvard when he had a course in property law, and he named the professor, and he basically suggested, maybe I ought to get that professor down here to sit right at my side here and tell me what this stuff means, because it was pretty amorphous, vague stuff to him. And Linda Greenhouse points out that after reading the majority opinion of 17 pages, she was not impressed at all. It was really, nothing struck her. It didn't seem to be relevant, which kind of was consistent with her thinking going in. She hadn't heard of the case. She didn't know that the court was about to decide this case, and there was nothing about the case that signified anything significant. And then she said she read Justice Sotomayor's Sotomayor's dissent. And there it was, the significance of the case. And turns out that the decision was potentially extremely significant. I thought it was when I read Linda Greenhouse's article. And so that's one of the issues that I want to bring to the table here at the Virtual Center, because I do think that Justice Sotomayor is right, and it is a significant ruling on the part of the Roberts Court. Then, of course, there was the ongoing saga about the Common Core standards. I received an email from one of our listeners today, Gene, and it was a link to a column in an Indianapolis newspaper, which suggested that just yesterday, Indiana became the first state that had initially approved the Common Core standards. It was one of the 45 states, plus the District of Columbia, to endorse the Common Core standards. Indiana became the first one of the approving states in the Common Core situation to back out of its commitment to the Common Core. And the implication of the article is that it probably won't be the last. That there are a number of states reconsidering their initial approval of the Common Core. And it is becoming a significant issue, political issue. And of course, it is a significant issue anyway because it deals with the educational future of the children of this nation. I would suggest to you that makes it relevant. But beyond that obvious point, the fact of the matter is that the Common Core is, we're beginning to see the Common Core as being in the middle of this ideological struggle between conservatives and liberals, between Tea Partiers, and of course Indiana is one of those states with a Republican legislature and a Republican governor. You may remember several months ago we looked at a situation when former Indiana Governor Mitch Daniels, who, if you remember, at one time was a proposed candidate for the Republican nomination in 2008. When Governor Daniels made an impassioned statement to the public schools of Indiana and pointed out that none of them were to utilize textbooks in American history written by Howard Zinn, and criticize Howard Zinn's reputation as a scholar and his honesty and his research skills and everything else. And so now there's a different governor in office, yet another Republican, and Indiana has rescinded its initial approval of the Common Core standards. And the article, in fact, and I thank Gene for this, the article points out that Oklahoma is among many states that are considering different standards than the Common Core, or at minimum are requesting a waiver or a postponement of the application of the Common Core standards. And so there's no question that this is becoming a very, very ideologically explosive issue. And I think it's one that we would be well served in kind of keeping up with and following, because I think it's very significant. Before we get into any of these issues, though, I did want to, the last time we were together, which was almost a week ago, it was 6 days ago, last Wednesday, I believe the date was the 19th day of March, we focused our entire program, our entire 2 hours that day, on a New York Times article on the philosophical issue of people finding ways to feel that they matter. And following that, we really haven't had an opportunity to follow up on that, on that particular issue. We didn't have our phones last week. And so there really wasn't an opportunity for people to express themselves in person on the air about that particular issue. Well, now that we do have our phones, and again, the number, area code 304-658-3333, I wanted to at least provide an opportunity for those who might have an opinion or a position on this issue that they wanted to share. I wanted to at least provide that. I wanted to provide that opportunity. And what I thought that, that it would probably be a good thing today is briefly to spend a portion at least of our first hour together reviewing that article and looking at what I think are reasons why it seems to be so incredibly significant. I mentioned last Wednesday that I had introduced that article in a senior citizens class the day before, last Tuesday, a week ago. And we didn't get but halfway through the article. It's a 1 hour class. So the senior citizens encouraged me to bring the same article back today, and so that we could complete it. And so once again this morning, we spent the full hour on that article. And as I mentioned last week, I'm particularly sensitive to the way that senior citizens respond to that article. Because there's absolutely no question that as we move closer and closer to the time when we'll all be leaving this earth, trying to find ways to make sure that we really mattered, that we accomplished something, that people won't forget that we were ever even here, becomes more and more significant as life goes on. Young people, obviously, don't even think about that. But the fact of the matter is, there's no way in the world as one gets older that one is not going to think about, has my life had consequences? Has my life really mattered? have I done anything that might be memorable so that people would remember that I was here? I'm always struck, this is a personal situation, but at the time I recognized the significance of it. It was probably 10 years ago. I've returned to it, reflected upon it many, many times since then. And it's one of those happenings, one of those incidents that happens in your life that even though I return to it over and over again, it never loses its relevance. It strikes me as significant now as it did when it happened 10 years ago. And it's very simple. I have right in the same neighborhood in which I live. I've lived in the same neighborhood here in southern West Virginia since I came here in 1991. And two houses down on my street, there was an elderly lady that lived there when we moved in 91, 92. She was a very, very accomplished musician. She played keyboard, piano, and organ in a couple of churches locally. She had been a music major at West Virginia University. She had a degree in music. She was an extremely accomplished musician, extremely bright woman. And my wife at the time and I were drawn to her because she was one of these incredibly significant people that you run into your life and say, this lady is in her 80s and she may not be here that long, but we can't live this close to her and not do everything we can do to spend as much time with her and conversing with her as possible. So we used to take her out to lunch periodically, just so she could get out of the house. She couldn't drive. She had a car, and obviously she could use it in emergencies, but she was really reluctant to drive. Her eyes weren't that good, and she wasn't that confident about her abilities and her driving skills. So the car would sit there, and she would occasionally go out and let it run for a while just to keep the battery charged. But basically, to go to the grocery store and stuff, she would always depend on somebody to take her. And increasingly, we were that somebody because we just enjoyed the time we spent with her. She passed away about 5 years ago, I think, now. But anyway, in the course of talking with her one day, visiting with her one day, and having coffee one afternoon, she took us down to the basement, and she wanted to show us that in the basement, stored in which was really kind of a musty basement actually, she had boxes upon box of her private papers, letters, things that she had written, music that she had played with, as in terms of her stabs at composing music. And she had, a couple of piles of papers stored in the basement in cardboard boxes. And at the time, I can remember making a comment to her and saying, her name was Blanche. And I can remember saying, Blanche, it's awfully musty and humid down here. Are your papers going to be safe and preserved? And she said, well, I really don't have much option. They'd probably be better off up in the attic, but I can't get them up there. And they've been down here so long now that it would probably be, if there is any damage to them, it's too late to move them now. Well, I thought about that, and, off and on, and lo and behold, about 5 years ago, Blanche passed. She went to a nursing home and passed away a couple of months after she arrived there. And her family, the family that she had left, and she had never been married, but she had two sisters, and they had husbands and sons, and so she had nephews and nieces and all that. The family showed up one day with a van in order to clean out the house because they were going to put it up for sale. And we walked down the street. We knew her her family not very well, but we knew them. We wanted to go down and say hello. We went down there, and it just so happened that they were in the basement. And they were cleaning out the basement, cleaning out all her papers. It turned out that when they moved these stacks, these cardboard boxes, there was so much humidity there that literally they were sitting in water, and they were pretty much rotted. And the fact of the matter is, one of her nephews had a snow shovel, and he was shoveling her papers off the floor and throwing them in a trash can. And then when the trash can was full, he would take it upstairs and put it in the van for disposal at the dump. And then he brought down another trash can and did the same thing. Two trash cans full of Blanche's papers, put in there with a snow shovel. And all I could think of was, here is everything that exists about this woman going into those trash cans, and they're just shoveling it up with a shovel. And it seemed so impersonal. And all I could think of is, when they drive away from this house with that van, and those two trash cans full of papers, everything that ever says that Blanche was ever on the face of this earth would be gone. There was nothing in the house left. There was no indication that she was ever there. And I found that so sad. And I couldn't help but think about it when I was reading this article that we looked at last week on ways throughout history that people have tried to prove that they matter and that their life has meaning. It's really significant. And as you'll recall, and please forgive me for reviewing, but especially if you remember this, but the fact of the matter is, it was almost a week ago, and obviously we can't remember that much. But if you remember, the author, a philosopher, the author was talking about something called a clout score. And what prompted it was that a friend of hers had gotten 2 reservations in this very prestigious restaurant in New York that usually required that you make reservations months in advance in order to get in. And she made the reference to her friend and said, how did you, how were you able to pull this off and get reservations so quickly? And her friend mentioned something called a clout score. And when she asked what a clout score was, she said, oh, it's a website. She said, I didn't know what a clout score was, but I was pretty sure that I didn't have one. And then she said, after I admitted that I didn't use Facebook or Twitter or any of the other social media, therefore I was unfamiliar with a website called Clout, which calculates your online influence. What kind of tracks you're making online, how popular you are, how prominent you are, how many times people go to your Facebook page in order to look up information or find out things about you. And based on that, there's a website called Clout that calculates your online influence. And the author of the article, whose name was Rebecca Goldstein, the author points out that in her study of ancient Greece, that the Greeks were just as concerned about whether in fact they mattered as well. And they had a word for it. The word they used was kleos, K-L-E-O-S. And kleos meant fame. But the actual translation of the term, of the word kleos, didn't just mean fame. It also referred to the deed that you performed which brought you that fame. as well as the record of that fame, whether it was a poem or a song or, what it was that allowed people to replicate your deed so that other people could gain the benefit of knowledge about the particular deed that you did. And all of that, as she says, the medium, the message, and the impact, all of it was captured under this one term, which was called kleos. And she points out that kleos was very, very critical. It was at the core of the Greek value system. And basically, it revolved around the human need to feel as if our lives matter. And because it was focused on a particular deed and it was associated with fame, the Greeks logically assumed then that kleos was something that only belonged to the few. It didn't belong to the many. That kleos was the way that you distinguish those people who have made a significant contribution to society as opposed to the vast majority of people who never experience that. So the argument, of course, among the Greeks was that it would be very important to people to accomplish meaningful things and to have those accomplishments recognized by those around you, by other people, other mortals. And so, in a sense, what Dr. Greenberg, the author of this article, Greenstein rather, but I think I got the wrong name, it's Goldstein. The point that she's making then is that to the Greeks, the way you measured your worth or how much you mattered was by tracing it to other people. In other words, the measure of your significance was to be found in the way other people responded to you and to what you did, what you accomplished. And the story or the poem or the song or whatever was created, which gave people an opportunity to relive your experience, your good deed. And then she makes that, uses that as the basis for the next move into the Hebrews. And the Hebrew tradition of establishing a very particular relationship with one of their tribal gods, which eventually became to them the one and only God, the master of the universe. And one of the things they recognized was that this master of the universe took special interest in the day-to-day lives of all who worshiped that God. And so therefore, the degree to which you mattered to the Hebrews was measured not in what other people thought of you, but what the one and only God thought of you. And so consequently, it could be that you weren't thought of that highly at all by the people around you. But as long as you mattered where it counted, namely in the eyes of God, that meant that your life had meaning, that you had accomplished something, you had done something worthwhile, something that was worth remembering and retelling and sharing with other people and later generations. And then she points out again with the Greeks that there was yet a third approach toward measuring the degree to which we matter, and that was totally internal. That was the message from the Greek philosophers who argued that it's the examined life that matters, not the unexamined life. In fact, Aristotle made the very famous statement, the unexamined life is not worth living. And so the assumption here then is the way Plato would phrase it. The whole idea of mattering, of living a life that is significant and meaningful, is to get your soul in order. Get your life in order. Educate yourself and spend time thinking about and reflecting upon and seeking to know as much as you can about the world around you. Pursuing issues like justice and wisdom. And the Greeks believed that it's the people that were most successful in doing that that are the ones worth remembering. And it doesn't matter whether others recognize your accomplishments or not. What matters is that you do. And I guess the best example that Dr. Goldstein uses in this particular article is Socrates. Socrates was tried and found guilty and condemned to death for messing up the minds of the youth by asking these very uncomfortable so-called Socratic kinds of questions, which were designed to drive people into better, deeper and deeper understanding of the most important issues of the day. And to those in Athens, the powers that be, this was incendiary activity, behavior on Socrates' part, to the point that he was tried and convicted and sentenced to death. But if you've read Plato's Apology, Socrates never for a moment questions what he did. He's very comfortable to the very end. He's very comfortable that what he did was right. And that's all that mattered to him. The fact that they found him guilty is rather insignificant to the fact that in his own mind he knew that what he did was right. And then this article moves into the Greek and Hebrew contributions to Western civilization and points out that the major significant difference between the ancients, Greeks and Hebrews, and Western civilization is that in Western civilization we have moved from the idea that only a few create great deeds to the idea that all of us matter. We talk about democracy, which had its roots in Greece. We talk about the nature of a republic, which we've talked about a lot here at the Virtual Center. But the most significant aspect of this is we as a culture are committed to the idea that all of us matter. Some of us believe that because we're all citizens, because we live in this republic. And we are all driven, if you will, by Jefferson's very famous statement that all men were created equal and that they are endowed by their Creator with certain unalienable rights. So consequently, the republic that the founders created and those governments that this republic that our founders created, the impact that their creation had on other nations throughout the world since 1776 suggests that in contemporary society there is a basic assumption going in that all of us matter. And so consequently then, in the kind of world or environment we live in, the belief is that everybody ought to have the opportunity to prove that they matter. And in order to have that opportunity, people must be free. And they must be given a fair chance, an equal shot at reaching their potential, whatever that potential might be. And in the minds of many people, there exists the assumption that everybody has something to contribute to the community at large. All of us have a significant contribution to make if only we're given the opportunity to find out what that contribution might be. If we're given the opportunity to examine, to reflect on our own abilities and our own talents and our own desires and our own likes and dislikes, and that eventually, if given the required encouragement and opportunity, all of us will be able to use their freedom to find the way that each of us can best contribute to the community at large, to the good of the whole, to the general will, the common good, the public interest, whatever phrase you want to use. And the conclusion of Dr. Goldstein's article is that, in a sense, one's clout score, how much one matters online, provides our contemporary opportunity to announce to the world that we matter. And so consequently, the latest technology is being used to speak to the world. In this Chinese restaurant, the sushi restaurant, let's just say Chinese, Japanese restaurant, the sushi restaurant, people are taking pictures on their cell phone, with their cell phones, of the meal that they have been served, and putting it on their Facebook page and as an attachment in Twitter, in order to let people know where they are and what they're eating, because the implication is it's significant. I am eating in a restaurant that takes months to get a reservation. And she points out that potentially this is a very, very positive thing. What it suggests is the latest phase of a tradition that goes all the way back to the Greeks and the Hebrews, of trying to prove and demonstrate that we matter. And how very, very important that is. All of us who have ever been in a situation of managing other people, if we've ever been a shift manager at a fast food place, it doesn't matter where we work, chances are that at one point or other, all of us have had the opportunity to manage other people. And one of the things you learn, sort of one of the keys in any kind of management 101 situation, is that the easiest way to manage people is to give people an opportunity to voice their opinions and voice their concerns and make suggestions and all the rest of it. There's no business or company or organization in the world that doesn't have a suggestion box of some kind, whether it's a digital one or whether it's a physical one hanging on the wall. The implication is that people are able to work much more effectively with each other when they feel that they matter, and when they feel that their ideas matter, and that the organization or the company, whatever it is, values their opinion, values their experience, and consequently values their point of view. And what Dr. Goldstein is pointing out is that this idea of using cell phones in order to photograph where you are and putting it on your Facebook page, in other words, sharing your life with other people as you live it, not waiting until it's over and then going back and reflecting upon the most important or significant aspects of that life, but basically expressing what's going on in your life as it's going on, becomes a very, very significant part in the modern world of people's opportunity to make a case that they matter. And her point is that philosophy, in order to remain relevant, philosophers are going to have to take seriously the reality of the modern world and the social media and what people need in order to feel that they matter. We've talked about the employment situation, the creation of a digital environment which is becoming so technologically sophisticated that fewer and fewer of us can keep up with it. And many of us, consequently, drop out of the market. There just don't seem to be the kind of jobs that many of us can do anymore. So in so many ways, it appears that the individual is becoming less and less relevant, less and less significant. But psychologically, we can't deal with that because all of us have always had the need to feel that we matter, that we count, and that the fact that we were on this earth and we lived a life had meaning and relevance to the point that we're worth remembering. And the point that I was making last Wednesday when we covered this article was that in a program like the Virtual Center for the Study of the U.S. Constitution, there's absolutely no question that the very significance of the Constitution itself and its respect for individual freedom and its respect for opportunity and individualism and creativity, all of those things, it seemed to me, speak to the ingredients of giving people the resources that they need in order to demonstrate that they matter by reflecting or respecting individual freedom and by identifying the ideas of freedom and privacy and many of these other things that we talk about all the time. All of it is significant in man's effort to demonstrate his meaningfulness, moreness, the word that Dr. Goldstein used, which is, I think, a beautiful word, moreness. There's more to me than you know. When I go, you'll realize that there was more to me than you appreciate now. And all of us want to know that we have that we have that to look forward to. And that we left footprints. that we had meaning, that we mattered. I would suggest, and this was my point at the conclusion of our program last Wednesday, that what makes this particular nation exceptional, what makes America an exceptional nation, is not what we've done or where we've been, but where we could go. We have the opportunity here to give individuals the opportunity to matter in today's world to a degree that no other society in the world has ever had. We have the opportunity to make life meaningful for more people than any society in the history of the world. That's what our Constitution is about. That's what the founders created when they gave us this republic. And I think the degree to which we become exceptional is going to be measured by the degree to which we live up to the potential of the republic that the founders gave us. American exceptionalism is not measured by where we've been or what we've done, but where we might go and what we might do. And I think that's incredibly exciting. I think it's incredibly important. And in so many ways, I think it informs where we ought to go and what we ought to do and where we ought to place our priorities. Our emphasis on education here at the Virtual Center is not misplaced, because education in today's world lies at the very heart of creating lives that are meaningful. And one of the most incredibly dishonest, unfair, and unethical crimes that we as a society can create is to deny our young people the resources and the opportunities they need in order to demonstrate to the world that they live in that they matter. It would be immoral to do anything that would prevent people from doing that. If that's what we believe life is about, if that's what our culture, our history, our civilization has consistently shown throughout its history, is that people have always looked for ways to demonstrate that they matter, whether it's in a religious context or whether it's in a secular context. I apologize for the phone in the background. The fact of the matter is that we have an obligation to each other to do everything we can do to make it possible for people in this society to have every opportunity in the world to demonstrate to those around them that they matter, to leave footprints, to make tracks in the snow that don't disappear when the snow melts. All of us, it seems to me, have that obligation. And the degree to which we live up to it is the degree to which we are an exceptional nation. We haven't done it yet. And there are many people who don't believe that we should do it, because we're still hung up on this idea of success, of financial success and position, and the idea that only the few can do it, can make it, can live, can be meaningful, and live significant lives. Philosophically, we have an obligation under our Constitution to make that opportunity available to everybody. But realistically, we haven't yet adopted that objective and made it our own. And I would suggest the degree to which we become an exceptional nation is going to be determined by how willing we are to meet that obligation and follow through on it. I believe that this is incredibly important. That's why I believe that the Common Core standards are so incredibly important. If they contribute to making it possible for more people to derive and develop meaning in their lives, then it would be criminal to not do that. I would suggest to you, I don't know, I'm not a philosopher, and I don't know whether in fact the Common Core standards are the answer. But I do know that what we're doing currently is not the answer. We are losing too many. We are convincing too many of our young people that education doesn't matter. I would suggest to you that they are making that decision in many cases, in most cases, without any appreciation of what education might even be. And there seems to be a suggestion, an indication, that the Common Core might offer a way to begin to break through that. And the fact that so many people are opposed to the Common Core for reasons that have nothing to do with our young people, at least directly, it seems to me to be significant. As we approach the top of our first hour, before we put this issue to rest, and if we run a few minutes over and have to postpone our break a little bit, so be it. But I wanted to look at this article, that this link that Gene sent me from Indianapolis on the state of Indiana withdrawing its support from the Common Core. The governor of Indiana is Governor Mike Pence. And there's some concern in Indiana that while the Board of Education has withdrawn from the Common Core standards as Common Core standards, the fact of the matter is their own draft of the standards they want to use to replace the Common Core standards are in fact replicas of the Common Core standards. In other words, it appears that the state of Indiana is trying to walk both sides of the street at the same time. They want to withdraw from the Common Core standards, but they don't want to do anything that denies them access to federal funding. They want to keep their finger in the pot, so to speak, while they do it. And so one of the critics that is most skeptical about the Common Core standards, the kind of standards that Indiana proposes to replace the Common Core, is Dr. Sandra Stotsky, who is a retired University of Arkansas education professor. I know Dr. Stotsky. She's very, very prominent in education, in educational theory. She studied the Indiana Department of Education report that proposes its alternative to the Common Core. And what she finds is that what Indiana came up with is not that materially different from the Common Core. According to this article, Stotsky released an internal Indiana Department of Education report that found that more than 70% of the standards for grades 6 through 12 are directly from the Common Core, and about 20% are edited versions of the national standards. About 34% of English standards for kindergarten through the 5th grade were taken straight from the national standards, the Common Core, and an additional 13% were edited. Dr. Stotsky called the proposal a grand deception. She said that the State Board of Education is making a fool out of its governor. The governor is being embarrassed by his own Department of Education if the final version is too close to the Common Core, she said. And then the article goes into the origin of the Common Core standards. I find this particularly interesting for a couple of reasons. The first one is that the major objections to the Common Core have been political, not educational. The major objections to the Common Core standards have been focused on where they came from and who supports them and who didn't, and the fact that they were not teachers sitting at the table when the Common Core standards were actually written, but that the standards came down from on high, so to speak. And so the major objection to the Common Core standards has focused principally on where they came from, not on the standards themselves. And those that are most opposed to the Common Core standards have charged that the standards amount to a federal takeover of education and an end to local control over schools. Because by establishing a Common Core that applies to the whole nation, the local control that has traditionally been associated with education is being lost. So the major political criticisms of the Common Core standards have been political, that they are being imposed on states and local school systems from above, and that the government is using access to federal funding as a way to mandate the Common Core. That's been the conservative Tea Party criticism of the Common Core from the very beginning. I know that that's Dr. Stotsky's position. She is the author of some of the major criticisms of the Common Core standards because of where they came from and what they say. But the fact of the matter is that this criticism of Indiana standards is based on the fact that they are too close to the Common Core. So what we have here is an issue, I think a very significant one. Because what's showing its ugly head here is a little bit of duplicity and contradiction. Opponents of the Common Core are building up opposition to them because of where they came from. But what this position that Dr. Stotsky is taking in Indiana suggests is that the real basis of opposition to the Common Core is to the content, is to what the Common Core standards say, not where they came from. What this article indicates is that the effort to dismantle and disrupt the application of the Common Core standards in this country is political. And the strategy being used to defeat them is to suggest that these standards are being imposed. Only now do we begin to see that the real opposition is to the standards themselves. And the only reason we see that is because the argument is that the Indiana standards developed by the Board of Education are too close to the Common Core standards. That suggests that it's the content of the standards themselves that's driving these people, not where they came from or who's supporting them. But the only way they feel they can win is to suggest some sort of a federal imposition of common standards on our local schools and the denial of local control over our schools. But now what Dr. Stotsky is suggesting is that if 70% of the standards for the 6th through the 12th grade come directly from the Common Core, then all that's happening is the name is changed, but the substance is the same. In other words, same play, different actors. And that's not what they want. They want the content of those standards dismissed, dissolved, abolished. But they're afraid to say that. The fact of the matter is, experts on both sides of the debate over the Common Core standards are very similar to the standards previously used in Indiana. Any program that any state adopts as an alternative to the Common Core standards is unlikely to be that different from the Common Core standards because the Common Core standards are Common Core standards. The only way to significantly differ from the Common Core standards is to offer something as a replacement for them, which is not education at all. And I would suggest to you, with our dual education system of a certain quality of education for the few and the mass education for the masses that we've been operating under, that's what we've had. And we better do something different than that. Michael Brickman, who is National Director of the Thomas Fordham Institute, which is a conservative education think tank, says, and this is a quote, "What you are seeing is unsurprisingly pretty closely aligned to the Common Core. The core of the Common Core is still very much in place." The irony of this article, which is about Indiana's pulling out of its support of the Common Core, the irony of this article is that the Common Core standards remain what we need. And those people that are opposed to it are opposed to what the purpose of the Common Core standards are designed to do, which is educate the masses, not just the few. Opposition to the Common Core standards is based on the elitist tradition that American education has been under since the beginning. The idea that only the few can benefit from education and not the many. I would suggest to you that this education is based on opposition to the very basis of American exceptionalism that we've been talking about for the last hour. And it seems to me that the Common Core standards offer much greater promise towards fulfilling that commitment of giving everybody the resources and the skills they need to demonstrate to the world they live in that they matter. That is the essence of what this republic is about. This is a very, very important controversy. And there's some really duplicitous stuff going on here. The fact that Indiana would pull out of the Common Core standards and then come up with standards which are 70% the same suggests that Indiana is much more concerned about being politically correct than it is in taking issue with the educational substance of the Common Core standards. But it also suggests something else. It suggests that Dr. Stotsky and those people who are really behind opposition to the Common Core are opposed to the content of the standards, and they're using political, ideological arguments to win their case. I think we need to focus on what it is that these people are opposed to about the Common Core. It doesn't matter where the standards came from if they promise success. But to the real critics of the Common Core standards, the success that the Common Core seems to make possible is not the kind of success that these people want. We are talking about a commitment to the tradition of elitist education and opportunity and success for the few, rather than the mission of this republic to provide equal opportunity and educational opportunity for everybody. That's the real issue here. And there are some people that are opposed to it, but they will never admit that. So instead, they will focus on all of this political jargon about who supported them, and Bill Gates' money's behind them, so there must be something bad about them and all the rest of it. But when they complain about Indiana's standards as being too close to the Common Core, they are letting us peek into the real issue. They're giving us a glimpse of what the real issue here is. They don't like the content of the Common Core standards. They don't like what the Common Core standards are intended to do. But they can't afford to say that. Wow. We are at 12 minutes after the hour. We're going to pause a little bit late today, but let's pause for 4 or 5 minutes and take a break, and we'll come back and we'll do our last 40 minutes of our program. This is Bill O'Brien. You're listening to the Virtual Center for the Study of the U.S. Constitution and Civic Responsibility. Please stay with us. After a short break, we'll be right back. Thank you, Bob Kincaid. And for those of you just joining us, welcome to today's edition of the Virtual Center for the Study of the U.S. Constitution and Civic Responsibility. I have to keep saying that title because it's so tempting to just say the Virtual Center. But if there's somebody listening for the first time, I want them to know about Virtual Center on what. And so, anyway, it is a pleasure. If you're just joining us, thank you for joining us. We really appreciate your willingness to give us some of your time. I know that time is a very precious thing for all of us, and the fact that you would take the time to listen to this program and hopefully respond and offer your suggestions and your reflections on what's going on here is something that I truly value and treasure, and I mean that. For those of you who've been with us since the beginning of today's program, I want to thank you for staying with us. I trust that if you are still with us, it's because there's something we're doing that you're finding valuable and important. I hope so. We work very hard to try to make sure that is true. Where our phones have been down for a couple of weeks, they are back in service now. We would love to hear from you on the issues that we were just discussing, or other issues of the day, the Common Core standards or the role of the Supreme Court or whatever. The phone number is area code 304-658-3333. That's 304-658-3333. My email address, and I might point out that it's an email from Gene. The link to this article about Indiana pulling out of the Common Core standard support. I just received that as that link from Gene, a listener to this program, and I appreciate it so much. And I look forward to hearing from you as well. My email address is waobrien906@gmail.com. That's waobrien906@gmail.com. For those of you just joining us, we spent our first hour reviewing the issues that we were looking at, the article that we were focusing on in our last program last week on finding ways or to prove that we mattered, that our life mattered, that we had meaning or significance or whatever. And we talked about that. But what I try to do, because I really think it's significant, the purpose of the Virtual Center, it seems to me, is to deliver the kind of information and the kind of insight that makes appreciation for our constitutional system and appreciation for the founders, from what they were trying to do, for what they believed and what they were trying to do, and what they were trying to leave for us. I think that too many of us really are unable to appreciate the depth and the value of what the founders left us. And I think it's very significant. And I think much of what's going on today in terms of our political debates and our ideological differences of opinion today are based on misinterpretation and misunderstanding of the founders and of the constitutional system. And that's one of the reasons why I found this Dr. Goldstein article, Rebecca Goldstein's article, on the tradition, the Greek traditions and the Hebrew traditions of people trying to find ways that show that they matter. That's why I think it's so very significant to the Virtual Center, to what we're doing here, because our constitutional system is based on the principle that we all matter and that all of us need to have our privacy and our opportunities and our freedom to pursue those opportunities respected and defended. That's what our constitutional system is about, despite the efforts of some to suggest that the only success that matters in this life is material success. The Greeks wrote an awful lot of very persuasive literature to suggest that there's much more to life than that. And we owe an opportunity to all of our people to give them access to that. And whatever we need to do to make that access possible, we have an obligation to do. That, I repeat, that is the basis of American exceptionalism. How exceptional America is going to be based on how well we fulfill that mission. It's not based on how much money we receive or where we stand in the distribution of wealth in the country or in the world or whatever. It's going to be based on what we are able to accomplish with what we've been given. And as a society that is committed to the idea of equality for all, we have an obligation to make available the resources and the kinds of educational opportunities that make it possible for all of us to attain the kind of success which would fulfill our psychological needs. That's what this nation's about. That's what we need to be about. And that's what we need to be doing. And I think that more and more this political controversy going on over the Common Core standards is really about that issue. The debate here, the issue on the table, is whether we are really going to follow through with an effort to try to give equality of opportunity to everybody, or whether in fact we're not. I would suggest that those people who are the most hardcore in opposition to the Common Core are in a position where they are asked to defend an educational system which is only working for the few. It's not working for the many. Employers can't find employees who have the skills necessary to work in the modern age. Businesses are telling us, employers are telling us, scholars are telling us, educational leaders are telling us, political leaders are telling us, everybody's telling us that we really must undertake serious change in order to make our education begin to accomplish what we hope that it will accomplish. And I would suggest to you that those people who are opposing change because it's change find themselves in a position of trying to defend a system which works only for the few, not the many. And they will not allow themselves to be backed into that corner. They can't argue their point of view on that basis. So what they must argue is political imposition from above, a desire on the part of government to take away local control over our schools, in effect to take our children away from their parents, and all of this other horrendous stuff, which is all really a cover for their real opposition to the Common Core standards, I believe, which is based on the fact of fear that they might actually work, that we might actually begin to undertake some change in this country that might affect the quality of education being given to the vast majority of our young people. It's unbelievable when you put it that way. But I would suggest that opposition to change is unconscionable when the reason for that opposition is because it might work. And to conjure up all of these other fictitious arguments against it, I would suggest, is unconscionable. It's unethical. It's immoral. It violates the very basis on which this nation is created. And I think we need to continue to pound away at that, because I think it's very important. One of the issues that I mentioned at the beginning of the last hour is, and we're moving right towards the bottom of our second hour. It's 27 minutes after the hour. So we've got about a half an hour left, about 30 minutes left in our time together today. I mentioned an article by Linda Greenhouse in the New York Times on a recent Supreme Court decision. Up until today, when the case was argued before the court about the Hobby Lobby case on First Amendment, this was the most recent decision. This is an article that was published in the New York Times on the 19th of March, which was last Wednesday, actually. And I mentioned it, and I mentioned the fact that she came into it blind and didn't really know the significance, and even after she read the majority opinion, she couldn't tell the significance. Let me share a few of the details with you about this case. The case, in fact, she says, is something that she knew nothing about. The title of the case is Marvin M. Brandt Revocable Trust versus United States. Marvin M. Brandt Revocable Trust versus United States. And Linda Greenhouse says she knew nothing about the decision until she downloaded it from the court's website. And she says, in that state of ignorance, I was like most people who tend to look, encounter Supreme Court decisions without any prior knowledge of the case or what the judges were doing. In a way, she says, I was approaching this decision like most people approach Supreme Court decisions, without knowing whether in fact it was relevant, and if it was, how. I was cold. And she said, after reading the 17-page majority opinion by Chief Justice Roberts, I still only had a vague sense of what the case was about, and no sense at all of why it might be significant. The case, she says, was a property dispute between a Wyoming landowner and the federal government that posed the question, as the Chief Justice put it, what happens when a railroad abandons its right-of-way? And you might say to yourself, if I saw a decision, a 17-page opinion of the Supreme Court, which focus around what ought to happen to property, to a railroad's right-of-way, what would cause me to even look twice at that kind of decision? And that's the question that she raises. She said the transcript shows that the justices were reacting with unreserved skepticism to the government's argument that it retained at least the surface rights to the 400-foot wide right-of-way following a railroad's final abandonment of its line in 1996. So what had happened is that the railroad company in question in 1996 abandoned the railroad. It wasn't using the tracks anymore. So consequently, the question is, what happens to the 400-foot right-of-way that the railroad was given $70 years ago? The vote was 8-1. And one of the reasons that the 8-1 decision was as it was is because the government, in this case, took the exact opposite position in a case that came before the Supreme Court in 1942. In other words, the government was arguing now that it ought to get the land. In 1942, the government argued that the property owner ought to get the land. And she says that even Justice Roberts, in his majority opinion, made the point and says the government loses its argument today in large part because it won when it urged the opposite before this court more than 70 years ago. So Justice Roberts is using the 1942 decision of the Supreme Court to deny the government's right in this one, and Justice Roberts is writing a majority opinion for an 8-1 majority. Then she said, Linda Greenhouse said, then I turned to Justice Sonia Sotomayor's dissenting opinion, trying to figure out what it was that caused her to dissent from the majority, the only one. She argued, Justice Sotomayor argued, that the old case, the 1942 case, shouldn't govern the outcome in this one, because in that case the issue involved was subterranean rights, the right to drill for oil, rather than surface rights that were now being raised as the issue. And then Linda Greenhouse said, I have no idea who has the better argument. But she said, in Justice Sotomayor's final paragraph, I came at last to a clue as to why this decision matters. And here's the relevant paragraph in Justice Sotomayor's dissent. Quote, the court undermines the legality of thousands of miles of former rights-of-way that the public now enjoys as means of transportation and recreation, she wrote. Lawsuits challenging the conversion of former rails to recreation trails alone may well cost American taxpayers hundreds of millions of dollars. In the margin of my hard copy of this article, I wrote "wow" beside that paragraph. I can understand why Linda Greenhouse made so much of that particular paragraph. Can we look at it again? In this 8-1 decision, Justice Sotomayor was saying, the court undermines the legality of thousands of miles of former rights-of-way that the public now enjoys as means of transportation and recreation. Lawsuits challenging the conversion of former rails to recreational trails alone may well cost American taxpayers hundreds of millions of dollars. The issue here, to be direct about it, the issue here is the rights of private property versus the rights of the community. To have access to this land, which was originally granted by government to railroads so that they could bring transportation to the area. Now the transportation by rail is no longer necessary. So does the land revert to government, or does the land revert to the original property owner? One of the comments to this article, I might say, because some of you are probably thinking this, the original property owner were the Indians. Maybe they should be the ones that get it. But that's neither here nor there, of course. So the issue that Linda Greenhouse raises is the issue of rails to trails. The fact of the matter is, in the 1980s, Congress responded to the abandonment every year of thousands of miles of rail. As we know, in recent years, the railroads have become less and less significant in America for transportation purposes, as we have fallen in love with the automobile, as of course everybody knows. The result is that thousands of miles of rail lines have been abandoned by railroads in recent years. In the 1980s, Congress responded to this abandonment of these public rights-of-way by enacting a piece of legislation called the National Trails System Act Amendments of 1983. Congress passed legislation in 1983 entitled National Trails System Act. This law gave states and localities the authority, acting under a federal umbrella, to convert the abandoned lines to public recreational use, rails to trails. At that time, in 1983, property rights groups challenged the law's constitutionality. But in 1990, the Supreme Court upheld the law in a unanimous decision. This case that was just decided last week by the Roberts Court refutes the Supreme Court's support for the National Trails System Act of 1983. The precedent that's being established here is that all of these thousands of miles of public land would not go to the general benefit of the people, but would revert to private property owners. What this case involves is this nation's inclination to sell off the commons to private individuals, to undo the work of conservationists like Theodore Roosevelt, who was responsible for setting aside tens of thousands of acres of public land for the common good. And we have focused programs in the past on the commons and the recognition throughout history that there needed to be common property owned by everybody. Property that was not susceptible to being fenced off or sold to private people. And what we're seeing here is the opportunities of certain people to take advantage of the lack of appreciation for the value of something we've called the commons, and to continue the process of selling off our public land, our public resources to the highest bidder. Potentially, what Linda Greenhouse spotted in this court decision was the extent to which the Roberts Court, the majority, conservative majority on the Roberts Court, is reversing legal traditions in America, which have been in place for 25, 30, 35, 40, 50 years. The recognition that government's principal responsibility is to represent the interests of the people, all the people, not just a few of the people. At issue here is the controversy, the age-old controversy between private property rights and the public good. And whereas the Supreme Court in the past has come down heavily, a unanimous decision in 1990, on the side of public lands reverting to government to be used for the common good, the Roberts Court is setting about reversing that tradition. And they're doing it in the dark. They're doing it in cases which are not making clear what the issues are. The general public is not aware, as Linda Greenhouse points out in this article. The general public is not even aware of what's going on here. And what she said, if it hadn't been for that one paragraph at the end of Justice Sonia Sotomayor's dissent, she said, I never would have seen the significance of this case. And I would suggest to you it's extremely significant. I'm reminded of the very famous speech, which we spent time with here at the Virtual Center some time ago. Theodore Roosevelt's very famous speech delivered in 1910 on the New Nationalism. And what Theodore Roosevelt was doing was defending the right of government to regulate corporations in the public interest. And Roosevelt's major position in that speech was that government's principal responsibility is to promote the public interest, not the private interest, when the two are in conflict. Obviously, Roosevelt says, we are not denying the rights of private property. But what Roosevelt is saying is that when the rights of private property conflict with the public interest, government's responsibility is to support the public interest, because if government doesn't, nobody does. Effectively, there is no public interest if government fails to support it. And this issue goes all the way back, if you remember, to the Marshall Court. In the decisions early on, the 1819 decisions in McCulloch versus Maryland establishing the constitutionality of the United States Bank. in which John Marshall in detail goes into the nature of corporations. And he first introduces the idea that corporations must be given the kinds of protections that persons are given under the Bill of Rights. Because the reason that corporations were created in the first place is because their very existence is seen as a contributor to the public interest. And government's responsibilities must always be to the public interest. Marshall's position in 1819 was that corporations need to be independent and need to have their rights and their freedoms protected, not because they're people, but because their existence and their creation is in the public interest. The public will benefit from what these corporations are proposing to do. That's why government created them in the first place. Roosevelt's speech in 1910 is totally consistent with that position. Government's principal responsibility is to support the public interest. Government's need to regulate corporations is because that's the only way that the public interest will be served in the face of this growing power of the private interests. Government must support the public interest because private interest will trample the public interest unless government is there to prevent it. In that speech, Theodore Roosevelt gives what is one of the most insightful defenses of progressivism that exists in this country. Roosevelt's position is in the defense of what he calls the new nationalism. His defense of progressivism is based on the idea that government has the right to engage in regulatory behavior, to pass legislation regulating the behavior of employers, regulating the conditions of the workplace, regulating protection of children by denying them the right to work in factories, child labor laws. In Lochner versus New York, the government of New York had the right, under its legitimate police power, to pass legislation mandating the maximum number of hours that people in bakeries could work because bakeries are unsafe. It's dangerous work. And to allow people to work an inordinate number of hours and to be get tired and become careless and potentially get seriously hurt. Government's responsibility is to protect the public from that. Because government's responsibility is to promote the public interest. And then Roosevelt says one of the most fascinating, insightful things about the public interest I've ever read anywhere. Roosevelt says that the whole meaning of this country is based on the fact that every citizen has something positive to contribute to the public interest, to the community at large. And since government's responsibility is to protect the public interest, government's responsibility is to make sure that every individual, every citizen, is given the opportunity to contribute to the public interest. He points out that working people obviously have a right and the responsibility to work in order to support their families. But part of being a citizen in this republic involves much more than the ability to work for an income. Citizens also have responsibilities as parents and spouses. They have responsibilities as citizens. And government's commitment to support the public interest involves making it possible for every citizen to make a meaningful contribution to the public interest. That means not in allowing them to be overworked or to be required to work excessive hours. Because in doing that, they are being denied the opportunity to make contributions to the public interest as citizens. They are being denied the obligation to make a full commitment to their families as husbands and spouses and fathers and mothers. So if every citizen is presumed to have something of value to contribute to the public interest, then government's responsibility is to make it possible for every citizen to contribute to the public interest. And that means that government does have the right to regulate hours of work, to regulate working conditions, to regulate the safety of the workplace, to regulate the health and safety and cleanliness of where people live, to guarantee people safe neighborhoods, to guarantee them fire protection and police protection and all the other things necessary in order for citizens to live a meaningful, balanced life in this republic. Consequently, part of government's responsibility is to protect the commons, is to make sure that there is public land, public resources available for the enjoyment of everybody. You don't take the public resources and put them up for sale to the highest bidder. You don't allow the interests of private property to trump the public interest. Government can't allow that. That's exactly what the Roberts Court did in this decision. Brandt versus United States. Marvin M. Brandt Revocable Trust versus United States. The issue, this was a Wyoming case. The railroad in question was small. But the potential significance of the case is huge because it will become the precedent for future cases. The same thing, and this is what I want to deal with in tomorrow's program, is this issue of the Hobby Lobby case before the Supreme Court, which was argued today, about whether, in fact, corporations are indeed entitled to the religious protections of the First Amendment as well as the free speech protections. Are corporations persons? Do corporations have freedom of conscience? Can they and do they practice the same kind of religious behavior as people? That's the issue here. That's one part of the issue. And I want to deal with that tomorrow. But it seems to me the issue of this property case is very, I think Linda Greenhouse is right. I think this is a very relevant case. Because it is the basis upon which, and one of the things we saw in looking at the origins of the Citizens United decision is that going back all the way back into the 1970s, the Rehnquist Court was establishing precedents which became the basis for the Citizens United decision. Remember the 1976 Supreme Court case in Massachusetts, First National Bank versus Bellotti, Bellotti was the Attorney General of the state of Massachusetts at that time. And First National Bank was arguing for its right to make political contributions in excess of the maximums that political contribution legislation had established in Massachusetts. In other words, the legislature in Massachusetts had passed legislation capping the amount of money that private corporations could contribute to political campaigns. And First National Bank wanted to exceed those caps, those maximums. In the 1976 decision, the Supreme Court upheld the constitutionality of Massachusetts Campaign Act, campaign finance limits. But, in the course of rendering that decision, the Supreme Court made it clear that whatever money corporations were allowed to contribute to political campaigns must be viewed in the context of political speech. There was the legal precedent for Citizens United. This Brandt decision that Linda Greenhouse is writing about probably will become the same kind of precedent for future decisions on rights of ways for abandoned railroads. Congress in the 1980s, in 1983, Congress made provision for taking these rights of ways from railroads that weren't using them anymore and converting them to recreational use of citizens in rails to trails in many of America's cities. Property rights advocate opposed it then, and now they've got a Supreme Court that is laying the legal groundwork for their successful efforts to overturn that legislation. One of the things that those who study the Supreme Court are beginning to recognize about Justice Roberts is that he's an incrementalist and that he's very, very aware of the fact that you lay one seed upon another seed and you create a paper trail which you can revisit later on as the justification for the decision on the table at that particular time. And just as the 1976 Bellotti decision, by defining corporate contributions to political campaigns as a form of speech, laid the groundwork for Citizens United in 2010. So also Linda Greenhouse's point and Justice Sotomayor's point in dissenting here was that that may be the exact same kind of precedent that the court is establishing with the awarding of these rights-of-way property, this 400-foot wide right-of-way to the original property owners. Private property rights are being allowed to trump the public interest. And that's where the Marshall Court is coming from, and that's where the conservative majority on the court is coming from. And it's happening without the general population being aware of it. It's very significant. We've talked about the commons before. We are at 59 minutes after the hour. Bob Kincaid's getting ready to start his program. I want to thank you for tuning in today to the Virtual Center for the Study of the U.S. Constitution and Civic Responsibility. Please have a wonderful evening. Be safe. We'd like to see you back with us again tomorrow. I'm Bill O'Brien. Thank you so very, very much.